Hello, everyone, and welcome to the latest Bristol Law Society webinar. As you'll note, we've had a late change of chair for this session, so apologies you've got me again. I've got a 2 o'clock meeting, so I will need to end the session on time, but hopefully that won't be an issue. In today's session, Nicholas Evans and Oliver Mitchell of Guildhall Chambers are going to be cutting through the noise of the recent changes to trial witness statements in the business and property courts. And there does indeed seem to have been a lot of noise about this. As usual, we'll be fielding questions at the end. Please feel free to submit them through the Q&A function as we go along, and then those will be picked up by Nicholas and Oliver after they've finished their formal part of the session. We'll also be sharing the slides after the event, and if you've got any colleagues who've missed the session and would like to see it, it will be on our YouTube channel, so please do subscribe to that. I've got Bristol Law Society, Joe Wicks and Blackburn Rovers on my subscription list, and I suspect that's quite a unique mix. So without any further ado, I shall hand over to Nicholas and Oliver. Thank you.
Thank you, Ben, for that introduction, and thank you everyone for joining this afternoon. As Ben has stated, this webinar is on the new Practice Direction 57AC on witness statements in the business and property courts. We intend to split this webinar into 2 parts. Firstly, I'll be speaking about what's actually in the practice direction and giving a brief overview of what the new changes are. And then in the second part, Oliver will be discussing and giving some of his thoughts about how best to comply with the practice direction and raising some of the problems that might arise moving forwards. And then also, as Ben pointed out, hopefully there'll be some time at the end if neither Oliver nor myself have been rattling on for too long. So, as I said, I'm giving a brief overview of the contents of Practice Direction 57AC, and I hope to be brief because 1, I'm sure most of you are already familiar with what's written there, and 2, I don't think it's much fun me just going through and reading out the Practice Direction. However, having said that, I don't think there's any substitute for yourselves going through and reading what are the 5 paragraphs in Practice Direction 57AC and the appendix to that. And so I'd recommend to everyone, if you've not already done so, to spend some time to go through and familiarising yourselves with what is actually said. So moving on to what the new changes are, I'm not sure if Oliver has started sharing the screen. If we can just put that up now, I'll wait for you to go full screen. And then so yeah, so in terms of the changes, I would categorize them into 3 different areas. There's one, I'd say, really what's happening is it's provided an authoritative restatement of principles that we already know and should already be applying. 2, that there are some new additional requirements that have been introduced. And thirdly, there are some sanctions that now apply. But before going on to deal with those, it's first helpful to remind ourselves of what the practice direction actually applies to. And this is set out in paragraph 1.1 and states that it's for witness statements for use at trials in the business and property courts, and applies to new and existing proceedings, but only to trial witness statements signed on or after the 6th of April 2021. So important to note there then that even where proceedings have already begun, any witness statement that's signed after the 6th of April falls within or potentially can fall within this practice direction. Paragraph 1.2 also includes some definitions, notably trial, which means a final trial hearing, whether of all issues or only one or some particular issues in any of the business and property courts under CPR Part 7 or Part 8. Now, some of you will notice that that's actually quite a broad definition of what a trial hearing is, and may include hearings which we might not readily think of as being a trial or a final hearing of that matter. And this is an issue that Oliver is going to deal with a bit further in due course. There is also a paragraph 1.3 which lists gives a set list of exceptions where this practice direction does not apply. And so, of course, I'd refer you to that paragraph to go through and see which areas of business and property courts that this wouldn't apply to. So moving on to then what, if we can move on to the next slide, onto the first point is saying that this is really just a restatement of principles that we should all really be familiar with. And this helpful quote from Mr. Justice Peter Smith in the Farpet case. This was after the case collapsed, he gave these comments. So it's completely unhelpful, for example, to have a single exhibit running to 700 plus pages appended to an affidavit which a deponent does not really understand and which does not tell the defendants what is the purpose of the large exhibit. And then the purpose of the witness statements is to replace oral testimony. It is not to rehearse arguments. It is not to set out a case. And whilst it necessarily has to be drafted with collaboration of lawyers, it should not be a document created in the language of lawyers by the lawyers, because the lawyers do not go into the witness box and defend it. And there's also a more recent case from this year of John Kimball QC sitting as a deputy judge, where he says, Mrs. Raymond's witness statement was very long, at 87 pages. It struck me at being somewhat overlaid document. I'd estimate that about 2/3 of it comprised long excerpts from her or her comments on documents. It did contain some of her own recollection, but that was unfortunately to a significant extent buried under a superstructure of reconstructed narrative based on documents. Her witness statement was therefore far removed from what would have been adduced from her in examination in chief. What she actually remembered emerged in a more natural and convincing manner for the first time in cross-examination. And then in respect of a different witness went on to say there were no facts in issue in relation to which oral evidence from her was really required at all. And I think that captures a flavour of really what this practice direction is getting to when it sets out in paragraphs 2 and 3 the purpose of practice direction 57A AC and also its content. And so really, the way I would characterize it is that actually this shouldn't come as much as a surprise to anyone about what ought to be in a witness statement, and in fact sets out principles which really we should all have been complying with prior to this practice direction coming into effect. And so the practice direction is helpful and it gives an authoritative restatement of these principles and also draws on other parts of the civil procedure rules. So moving to paragraph 2, which sets out the purpose or explaining the purpose of witness statements, it makes clear it's to set out in writing the evidence in chief that a witness of fact would give if they're allowed to give oral evidence at trial without having provided the statement. And that is, of course, already is set out in rules 32.21a, 32.41 and 32.52, and it's simply repeating what we already know and is already what ought to be, or rather what witness statements ought to be limited to. And then secondly, paragraph 2 makes clear that it's to help the court deal with cases in accordance with the overriding objective. And I would say that, and I'm sure Oliver would agree with me, that the best witnesses are those which provide concise statements that deal with the relevant topics in a concise manner and doesn't deal with tangential issues or seek to go beyond what actually that witness is supposed to be talking about. And of course that's helpful to a judge because they know exactly what the heart of the issue is, and two is normally invariably to the benefit of the client as well, because that's how you're best going to get across their case. So moving on to paragraph 3, we see this continuing in terms of what the content of the witness statements must include. And so we can see it must contain only evidence as to matters of fact that need to be proved at trial by the evidence of witness in relation to one or more of the issues of fact to be decided at trial. It must set out only matters of fact of which the witness has personal knowledge that are relevant to the case. And it must be in a witness's own words and, if practicable, be in a witness's own language. Again, that's already set out in part 32, but practice direction 57AC gives a slight gloss as to what is meant by language here, and says any language in which the witness is sufficiently fluent to give oral evidence. We can see how closely tied up this is all into what the purpose of a witness statement is for, how best it's used to, one, promote your case, and two, to comply with the overriding objective. Now to turn to what we see actually the new requirements that are now imposed by practice direction 57AC, and really there are three new requirements, one being the list of documents, two, confirmation of compliance by both the witness and the legal representative, and three, preparation in accordance with the statement of best practice. Now the list of documents, this is the a witness statement must contain a list of the documents that the witness has referred to or has been referred to for the purpose of providing the evidence set out in that witness statement. Now, at first sight, this might appear to be quite an onerous requirement to further add to the burdens of lawyers and solicitors. And indeed, this was the only matter in which the working group could not reach consensus on, with concerns about how practical this was going to be. And as a result, they did have a test drive to figure out what likely impact it was going to have. And that showed actually that the time to comply with this proved to be rather insignificant, and that the list was created from material that would have been generated in any event. And one can see that actually this makes, one can see why that might be the case, given that a good witness statement will always make clear in it matters to which the witness has personal knowledge and matters to which he's derived from elsewhere. Moving on to the confirmation of compliance. So each witness statement will need to include confirmation of compliance in two formats. So firstly, each witness statement will be required to contain a statement signed by the witness confirming that in effect they understand the purpose and proper content of the witness statement. I should note that since this requirement is stated as to be in addition to the statement of truth, one presumes that this has to be signed separately, i.e. so there's two statements to be included, although I'm sure we may have or guidance on that in due course. It's important to note at paragraph 4.1 of the practice direction that the format is set out in paragraph 4.1, and importantly, permission to vary or depart from it is set out at paragraph 4.2. Secondly, witness statements will need to be endorsed by a certificate of compliance signed by the relevant legal representative, confirming that they have, one, explained the purpose and proper content of a witness statement to the witness, and two, believe that the witness statement complies with the practice direction. Relevant legal representative is defined back in 1.2 with the definitions as a legal representative who is authorised to conduct litigation and has had responsibility or ensuring that the purpose and proper content of a witness statement has been explained to and understood by the witness. There is also, with regard to litigants in person, no certificate is required if they were acting as a litigant in person at the time it was signed, but there is this exception is subject to what one might term an anti-avoidance provision, which provides that the court may strike it out if there's reason to consider that the party was only acting in person to get around this requirement. And then finally, there's a statement of best practice. This is the appendix, which is appended to Practice Direction 57AC and contains a statement of best practice. Now, I'm not going to go through that document now as it is rather long, but I would just again recommend and urge everyone to go through it and read it, because it, I think, essentially distills and gets to the heart of what Practice Direction 57AC is all about, and how we should be approaching our witness statements moving forward. So now turning on to sanctions. So the final paragraph, paragraph 5, specifies a number of sanctions that the court may impose for non-compliance. Importantly, that these are sanctions in addition to powers that the court may already have in respect of witness statements or handling of evidence generally. And so namely, the court can refuse to give or withdraw permission to rely on or strike out part or all of a trial witness statement, order that the trial witness statement be redrafted in accordance with the practice direction or as may be directed by the court. 3, make an adverse cost order against a non-compliant party. And 4, order a witness to give some or all of their evidence in chief orally. I just draw your attention to the second bullet point on the slide, the redrafting, and just point out that the likely cost burden that might impose on a party, particularly if it's late on in the trial process. For example, if the trial window would need to be moved as a result of the witness statement being redrafted, one would assume that the cost of that are likely to fall on the party not complying with the practice direction. And I also just draw attention to point 4 as well about the witnesses in civil proceedings may on occasion be called to give evidence in chief. And so finally, just before handing over to Oliver, I would also just strike a note looking to the future and about how this practice direction may give an indication of where we're going. There, in the implementation report, one can see that this seems to be the general direction of travel, and that this looks likely to apply to all courts, with the harmonisation of the Commercial Court Guide, the Technology and Construction Court Guide, and the Chancery Guide. Further, that the removal of the page limit on witness statements in the next edition of the Commercial Court Guide, and also the possible introduction of detailed pre-trial statements of fact alongside witness statements. This was something that was considered as part of Practice Direction 57AC, but it was thought that this might be better dealt with alongside all of the alongside the judge's normal case management powers, or the court's case management powers generally, rather than specifically to deal with witness statements. Having said that, whilst one might expect judges to look at this and then apply it to their own proceedings, even if it isn't subject to Practice Direction 57AC, I would just draw your attention to a recent experience that I had in an application to set aside judgment recently, where solicitors originally thought that the application was going to be in the business and property courts, and so did a Practice Direction 57AC compliant witness statement. The judge, somewhat surprisingly, I thought, took exception to this and thought that it was excessive in terms of the extra hours that would have been, or extra time that would have been spent on drafting the witness statement. Now that's slightly at odds with what I've been saying previously, in that one might say that actually witness statements being drafted shouldn't take too much longer to comply with this, because that's really what should have been happening all along. So I think it just goes to show that how judges actually seek to implement this may vary depending on who you come up in front of. So I think at that point I'll hand over now to Oliver.
Well, thank you very much for that, Nick, and for attempting to break down the provisions into a sort of manageable bite as much as is possible. It is quite complicated, and I would definitely echo what Nick said, that it is worth sitting down and reading, in particular, the statement of best practice as well as the practice direction. It's not that long, but it manages to pack in quite a lot in terms of what you should and shouldn't be doing, and in terms of the fact that solicitors are now going to find themselves in a slightly unusual position of actually having to put their own signature on the end of a witness statement to say that they're happy that it complies with all of this. It definitely bears having a proper look at. And in some respects, it's actually quite specific as to what you should or shouldn't do, which is probably quite welcome. It seems to me that a lot of the issue that arises when something like this change comes along is that it's all very well reading the rules and the practice directions that come with these things, but what we often benefit from as practitioners is knowing how things actually play out. And so when you get something new like cost budgeting, or like the disclosure pilot, or like now the new provision for witness statements in PD 57AC, you're sort of left scrabbling around initially with some points where you can't yet read between the lines because the courts haven't assisted us to do that, and there isn't a body of standard practice. And it's in that area where you would expect that some of those blanks will start to be filled in over time, but there obviously hasn't yet really been an opportunity for that to happen. And we're likely, of course, initially to be in a position where courts take their own individual view on things before maybe we might ultimately end up in a situation where we get some Mitchell or Denton style more authoritative guidance, but who knows. I think that it's useful in that context to really keep in our minds, when we're thinking about how we might approach things, what the actual underlying problem was. And this really goes back, I think, to being very nicely set out in the last of those three quotations from Mr. Justice Peter Smith that you saw in the previous slide. And I would break it down really as being a concern about three things: arguments, which again, we've all seen witness statements that argue things. We've all seen witness statements that argue things in the context of applications, maybe solicitors' witness statements. We've also obviously all seen lay witnesses arguing things in trial witness statements, and that's one concern. Second is commentaries, where you have a witness describing what you will see in other places, describing what other people did, what other people say, and editorials, which I would characterize as when you collect together what people might say, and as it were, it's all put into the mouth of one person, and that is perhaps what emerges in the Fairpack case as the real concern. That, I hasten to add, was not a case, as I understand it, where it was suggested that the case collapsed. The case collapsed because there were these issues with the witness evidence, but it's rather, I think, that Mr. Justice Peter Smith was concerned that it collapsed at the late stage that it did, because it became apparent only on unpicking all the evidence at trial that actually the evidence didn't really amount to saying what the Secretary of State needed it to, and the true evidential position was perhaps rather obscured behind the approach that had been taken to how it was presented. So it seems to me that as a starting point, there are some questions that we need to keep in mind, bearing in mind that the focus of this exercise is very much a reductive one. It's very much a case of not saying there's a problem with witness statements that don't contain things they need to. I mean, we're all going to come across witness statements that don't contain things that they should from time to time, but that's not really, I think, what this is focused on at all. The focus here is on witness statements that are saying too much of the wrong sort of thing, and things that really don't belong in witness statements at all. So I think in that context, some questions to ask. Well, the starting one: what story can this witness actually tell? So you are assisting a witness to commit to paper an account that he or she can give of the things that he or she actually knows about from the time. What is this witness's story, which is a separate question to the question of what is the account that the client wishes the court to have before it, because the answer might not be to just dump all of that into this witness's statement. Is there anything that should be dealt with elsewhere instead? So, for example, is there anything that should be dealt with by a different witness? Now, it's right that you might have a point where it is relevant that something was said to your witness, or where you want to establish that something was the case on a hearsay basis, on the basis that it was said to your witness, and that's fine, and that's recognised by the new provisions as acceptable. But it might equally be that really what you're trying to do is take a shortcut and just say what really somebody else is saying, in which case should that somebody else not be saying it if it's sufficiently important that you actually are trying to establish that in evidence? Is it actually something that can be dealt with simply by looking at a document? You will see again that this regime is reminding us that the purpose of a witness statement is not to tell us what documents say, when you can put the document in front of the court and the court can read it itself. So are you actually trying to give evidence of what a document says when the document is evidence itself of what it says? Or do you have something that really belongs in submissions? Do you have argument by a witness about what someone else says? She says this and she's wrong, or given that witness statements for trial will typically be being exchanged all at the same time, do you actually have a witness saying, if she says this, then she will be wrong? Apart from simply complying with the rules, I would take the view that there is a very good practical reason for keeping submissions out of witness statements in terms of serving the interests of your own client. It's nothing new, but it's something that this is asking us to refocus on, which is simply this, that if you have a factual dispute and you have witnesses involved in that factual dispute, the court is expecting that those witnesses will disagree. it will likely not find itself particularly assisted by hearing one witness explain on paper why she thinks that the other witness is not right. That's ultimately a matter for, well, on one level, cross-examination, on another for submissions. And of course, hearing why the other side's evidence won't be right, won't be acceptable before it's even been heard. Again, is that something that will assist a court? The court is looking ultimately to have submissions on the evidence that it's heard from the advocates, having heard the witnesses challenged on things that they disagree on. And if the submissions come earlier, then there's a chance, firstly, that they won't actually carry the weight that they should, because the court will see argument where it should be seeing fact. And equally, there's a chance that the court might form the view that you have a witness who actually can't really draw that distinction between what is fact and what is opinion or argument. And that's not necessarily the view that you would like to see the court take of a witness supporting your client's case, or your actual client. So those are some questions that I think it's useful to bear in our minds as we try to navigate initially how this new or newly restated approach is going to work in practice. Putting it simply, in other words, if we remember that this witness evidence is evidence in chief standing in for oral evidence that will be given in court, if we imagine the scene in the Crown Court, for example, if a witness is being taken through his evidence directly, if you took the witness through this in oral evidence, would the judge stop you? Would somebody stand up and say, you're inviting the witness to make impermissible comments? Would the judge ask, well, what's the relevance of all of this? Or say, I can read that document myself, thank you very much. If you are only dealing with the story that the witness can actually give as a witness, then you're probably in a good place. If you're trying to crowbar other things in, you're maybe not in such a good place. So it seems to me that there are two areas broadly that we need to be thinking about. The first is what can actually and should actually go in a witness statement. And the second is, what is the process for putting together a witness statement? And I'll come to the second one a little later and deal with that quite shortly, because actually that's something where a bit of reading is probably in order. But dealing firstly with what goes in a statement, it seems to me that there are a few potential problem areas as we're trying to get to grips with things from PD 57AC and from the statement of best practice, and areas where we might need to particularly think about things. One, of course, is telling the story, because technically uncontentious narrative is not supposed to be something that's in witness statements, because if you look at paragraph 3.1 of the practice direction, you'll see that they are supposed to be dealing with things that need to be established. And if you've got facts that everyone agrees on and no one's trying to establish at trial, technically speaking, that's considered to be something that you shouldn't be wasting time on in a witness statement. And that is very sensible on the face of it. Potentially, it brings about some difficulties, because a court is often going to benefit from being orientated in the story of what's happened, if I can put that broadly. We all know that pleadings, especially if they actually follow the CPR approach to pleadings, are not the place for the extensive backstory. They're the place for the specific facts that are needed to establish a cause of action. We know that narrative can appear in a skeleton argument, but again, it's not something where counsel particularly want to be having to tell the story in their skeletons if in fact the story is there to be told by the participants. So it's a very natural thing, and it's actually a very typical thing for, as it were, the main witness in a case on each side to set out the narrative of what occurred, focusing obviously on the contentious bits, but giving the whole picture. And arguably that's a much easier way to understand what a case is all about and where one is in it, than simply seeing a witness who says, this is the contractual issue I had, rather than saying I entered into this contract and we were fine until X date, when this is the point where the argument arose. Now, there are, I think, a couple of ways that could be dealt with. One is that, of course, in reality, it may well be that courts are not desperate to exclude bare bones narrative from trial witness statements, where it actually assists to explain very briefly the context of the key issues that are being traversed. And it might be that sort of narrative ultimately doesn't prove to be particularly controversial. Of course, it still pays to be alive to the statements that are being signed at the bottom of the witness statement. And if you say that you're not doing something, not to do it. But it may be that in practice, we don't see the courts coming out immediately and saying any narrative of anything that's not controversial, that's unacceptable, even if it helps to explain what's coming next, because that might just be the most efficient approach. And that's probably not really what the fundamental concern has been. The other possible approach, which Nick has already referred to, is potentially that you could have a separate exposition of the factual background, the agreed parts, the non-agreed parts. Now, we might see that, as Nick indicated, we might see that being directed. We might see it being something the parties agree on. Of course, it's worth remembering that there is, in fact, a framework for that already exists and is sometimes perhaps underused, which is a chronology. We see in directions that it's very typical that the court will say that a trial bundle be prepared, and the trial bundle shall include a trial timetable and a chronology. And often that chronology is simply produced because the directions say that it should be, or it's not produced because actually it doesn't feel to anybody like it's a dates case. But actually that document, if it's slightly repurposed, could be a vehicle for the parties setting out the narrative, even in a case that's not really about the specific dates. And it might be that the parties are able to say the agreement was entered into in 2014, between 2014 and 2018, this is how the parties proceeded. That sort of narrative that could be the uncontentious narrative framework that we would have seen in witness statements, that could be something that appears in what is effectively an expanded or repurposed chronology. And that could potentially be the way that we go. Another potential issue is the scope of the practice direction in terms of what is and isn't excluded. So we have seen there are some exclusions. You can find those at paragraph 1.3, and some of those are very clear. Some of them just refer to a specific type of claim or application and exclude it. Some are less clear. So one example that occurs to me is part 64, which relates to applications effectively for directions from the court in respect of trusts and estates. And it might be that there's a question mark over when that takes a particular claim outside of the scope of the practice direction. So, for example, is a Talata claim, is an application in respect of a trustee under the Trustee Act, is that part 64? Is it acceptable to approach a claim like that on the basis that it falls outside of the practice direction? Of course, some claims of that sort might really never get anywhere near anything that looks like a trial, but others of them absolutely would. And even if you can satisfy yourself that they fall within the ambit of part 64, does that actually make it appropriate to not follow the PD 57AC approach? Similarly with part 8 claims, part 8 is not excluded. You can see that at paragraph 1.2. In part 8, we have the unusual situation that witness statements are needed effectively at the outset, which means that the witness statement you're producing at the start of the claim is a witness statement that on the face of it would theoretically be what you would catch as a trial witness statement. Again, whether or not the matter ever gets anywhere near anything that looks like a trial. And of course, part 8 applications claims are often used for things that look much more like interim applications in part 7 claims than that look like a trial. So again, you may find a situation where you've got a part 8 claim that you're having to pursue in order to bring your application, which feels like it's very much not something that ought to be caught by PD 57AC. Feels like something, for example, where you might have the solicitor giving a witness statement, but at the same time is not obviously excluded. And then obviously we have the question of the county court, and you've heard Nick explaining how he had one case approached in the county court. The county court is not formally subject to the practice direction, but the practice direction is trying to restate good practice, and good practice doesn't, of course, stop at the door to the High Court. And for the most part, good practice in one court is going to look a lot like good practice in another over things like this. So to what extent can you simply say, well, this is in the county court, so the requirements of the practice direction go out of the window? And to what extent should you say that, even if technically speaking you don't have to cross certain T's and dot certain I's? Do the fundamental considerations not still apply, because they are about how we ensure that evidence is as effective as it can be in front of the court? Ultimately, what judges insist on, and again, this is Nick's point, is I think going to be a matter for individual judges, initially at least. But there's a real question about whether we oughtn't to be adopting one unified approach, even in cases where technically PD 57AC doesn't apply, because it's, as I say, trying to restate good practice. So some thoughts that occur to me about that is as a starting point to think about what you would want if you were the judge, because of course judges are busy people and they are trying to decide complicated cases fairly often on some rather confusing papers that come in front of them. What do you think would assist? So obviously if the practice direction prescribes something, that you do this or you don't do that, if it tells you that you shouldn't include something in your statement, obviously you don't want to depart from that. But if you've got a marginal case where the matter is not technically within the practice direction, but you think that maybe some of the practice ought to be ported over, or you've got a matter where it's within the practice direction, but there's a sort of hazy line as to what's in and what's out, and you're trying to work out where to draw that line. A useful starting point, I think, is to think, well, what would you want to see as a judge? Is this paragraph that you are thinking about cutting out of a witness statement, is it actually, is it commentary, or is it just simply helping to explain the paragraph that's coming next? There are going to be judgment calls, but trying to look through the eyes of a putative judge is maybe not a bad starting point. And following on from that, the other thing I would suggest at the moment, which often is quite useful in a lot of points in litigation, is to think about showing your working, by which I mean explaining what you're doing and why you're doing it if there might be some uncertainty. So it's perhaps the same as if you're making a slightly unusual application to court and you explain why you recognize that that's a somewhat unusual application, but you've made it for a particular reason. And in this case, it might involve explaining that you've not included something that you ordinarily would to comply with 57AC, or it might involve saying that whatever you've done, you take the view that it complies with the practice direction or the spirit of the practice direction or whatever it is. If you are taking a particular approach and you explain what you're doing, then I think that has potential to do two things. The first is to satisfy the judge that the approach you've taken is a satisfactory approach. But secondly, given that we're in a period where we're exploring how this is going to work and there's not a huge amount of guidance to go on yet from case law, it puts you in a position where if the judge actually doesn't like your approach, you're perhaps more likely to get some judicial guidance in the judgment for the future and less likely to get a judicial telling off and to get the judge thinking about the more forceful end of the sanctions regime that's available. If you show that you have tried to put the matter before the court in a way which will assist it and a way which is fair, then it's much more difficult to criticize the approach that you've taken. Obviously, what I would say as well is don't say one thing and do another, which is to say if you're obliged to follow the practice direction 57AC approach and you are signing off on those statements at the bottom of the witness statement, or if you've decided to follow that approach anyway, then do what you said you're doing. I mean, you're signing that document from a professional point of view and from a and not upsetting the judiciary point of view, if you say that you are preparing a compliant witness statement and you understand that X, Y, and Z should not be in it, don't then go and put a load of X, Y, and Z in it, because that's just going to cause upset. So those, I think, are some of the general considerations that we might need to apply very briefly to the process question. How do you produce a witness statement, and how do you deal with documents? And this is where it really does pay to read the statement of best practice, because it tells you what it's looking for. And I think it would be fair to summarize what it's looking for as clarity as to what the process is. It expressly sets out the concern that it's very easy for a witness's evidence to become polluted. And so when you are producing a witness statement, you are going to need to explain what the process was, and it explains what the ideal process for doing that is. You're going to need to keep a note of what the process was and to record how that worked. You're going to obviously need to keep a good note of the witness's evidence from which the witness statement is going to be produced, because under the practice direction, under the statement of best practice, it's very clear that the approach of getting some rough evidence from a witness, knocking together a witness statement from the lawyers, and then checking with the witness that that is actually the evidence that witness wants to give, that's not okay. You are going to need to actually get the witness's story in as open, non-leading, clean a way as you can from the witness, and then record the witness's story and set out any open questions that need to fill out that story if you're drafting the actual statement, and then send it back for more unpolluted input from the client. And similarly, when you're dealing with documents, obviously you're listing documents and listing documents that are referred to in the witness statement, but you are also going to need to be particularly careful, as it makes clear, with any documents which aren't actually contemporary documents that were in the witness's hands at the time, as to not waiving those in front of the witness and having a subsequent written account of something influence the witness's own recollection. And that is not only, again, because the rules require it, but also because you do not want a situation where the way that you have collected the evidence from the witness and the way that you've produced a witness statement leads the court to think that it can't actually have confidence that your witness's recollection is an accurate one anymore, because this is recognizing that witnesses can be honest and desperately inaccurate. Again, it's about, I think, showing your working so that the court can see what you've done, see what the process was, see what's being referred to at what stage, and so understand what the limitations of the evidence that might arise from that are. And that's not something to be afraid of, because what's really, I would suggest, to be afraid of is the court assuming the worst if you've got a witness who doesn't appear capable of recognizing the potential areas where testimony might have been influenced. So if that means that you take the witness through a process, if there's a subsequent document that the witness needs to consider, for example, maybe because it's your client and you need to discuss it, it might be a process of getting the evidence from the witness down firmly before you then go over those subsequent documents, so that you know that it's not been polluted from the outset. And just one concluding remark before we have a look at any questions is that this is a new regime in terms of express sanctions, in terms of being set out as expressly as it has been. These are not, however, new considerations for judges. The fact that judges are looking at whether a witness is argumentative, the fact that judges are looking at whether a witness appears to have read over a load of subsequent documents and might potentially have been influenced in her recollection of what's happened. All of these things, the sorts of considerations that Mr. Justice Peter Smith was thinking about in the Fairpack case, these are not new. These are things that judges have been routinely applying to their assessments of questions of fact for a very, very, very long time. And what we have now is a mandate to actually properly give these things consideration in advance. And as much as it may pose some interesting procedural questions for us and process questions initially, that I think is not something we should shy away from, because this is about forcing us to engage with what it is that will help a judge to assess our client's evidence, and to really, for our client's evidence to impact us and our witnesses' evidence to impact as well as it can, given what it is, and to make sure that nothing that we do in terms of our process as lawyers is getting in the way of that. So encouraging us to look at that and think about it. As I say, it may be some upfront pain, but it is helping to remind us what we need to do to make sure that judges actually are able to take witnesses' evidence at the highest that it's capable of supporting, and that's not something we should shy away from in trying to help our clients out. So that's just a quick little run through from Nick as to what some of the new regime looks like, and from me as to some of the things that we maybe don't yet know about it. And I hope that was somewhat useful. So I don't know if we should have a look at some of the questions.
Yeah, I can see there's some questions in the Q&A, which I'll try and answer them. There might be a question for you, Oliver, in the chat. So Jessica has asked, what do we mean by an Overlord document? The thing that comes to my mind first when trying to answer that question is, what's the purpose of a witness statement? One, it's in the clients, in their own words, in their own language, to put their cases, or rather the facts that are relevant to them. And so number one being, make sure it's in the language of the witness themselves, and not language that a lawyer might use, or language that is a bit alien to them. And you often find when it comes to trial or cross-examination, they say, oh, I wouldn't have put it like that, I would have said this. What I guess you're really trying to avoid is that scenario, and just putting something as the witness themselves would describe it. And two, that the witness statement is it's a statement from the witness. It's not an attempt for legal argument, as Oliver's been outlining. So I would say an Overlord document would also include things which seeks to go beyond the facts at stake. And we've all seen paragraphs which say, although I'm not a lawyer, I believe that X, Y, Z. To my mind, how helpful are those paragraphs anyway? And that to my mind at least is what I consider Overlord. Then just in looking at the next question, does the definition of legal representative include a barrister under the direct public access scheme? I would suggest simply that the answer to that is yes, although I'd recommend everyone to make their own judgment on that. But if one looks at the definition of relevant legal representative in paragraph 1.2, it states that a legal representative authorised to conduct litigation who has had responsibility for ensuring that the purpose and proper content of trial witness statements and proper practice in relation to their preparation have been explained to and understood by the witness. And then in brackets, and legal representative has the meaning given in Rule 2.3. And then if one turns to Rule 2.3, says legal representative means A, barrister, B, solicitor, C, solicitor's employee, D, manager, or body recognised under Section 9 of the Administration Act. So to my mind, that would include barristers generally, and also barristers under the direct public access scheme, specifically where they're providing the advice in relation to the witness statement.
And then there was a question in the in the chat, or two linked questions. How likely is it that final submissions make reference to documents which have not been put to witnesses during a trial, and or which opposing counsel have not been given the opportunity to comment on during the trial? Is this likely to lead to more counsel submissions referring to documents within trial bundles to ensure they are brought before the court? I think I would probably deal with that in reverse order if I can. Is it likely to lead to more submissions referring to documents? I think that the answer to that is probably yes, it is, simply in the sense that obviously we know that it's important to flag up the the documents that are relevant. Now, if there's a central document, it may well appear in a skeleton argument. Of course, if there's a central document, you'd expect to see it being put to a witness. But certainly in the sense that if you have witness statements that are no longer saying you can see this in this document, I think it's right that we can probably expect to see counsel taking a bit more time actually taking judges through documents by way of closing or possibly even opening submissions. How likely is it that final submissions make reference to documents which have not been put to witnesses or there's not been an opportunity to comment on? I mean, I think that the thing to make very clear, and I'm sure, Nick, you won't disagree with me on this, is that none of this is supposed to be an opportunity to ambush people with things or to be an opportunity to not put your case to a witness. So if a document is important and you say that it establishes something and you need to put it to the witness, that is still going to have to happen. And this is no excuse for anyone to, I think, deliberately depart from that. It may well, of course, be the case that if you don't have documents being referred to in witness statements as such, of course, it may be that you have a situation where it's not as apparent that each side is relying on those documents as part of their respective cases. And so you may have a situation where to some extent that may happen by accident, in the sense that it may not have become as apparent that actually there were things to put to witnesses. I think the onus really will be on the advocates presenting the cases to make sure that if there are important documents that they rely on, that those are set out. And frankly, you would hope that the parties, by the time they get to a trial, ought to have managed to identify between themselves what the scope of their dispute is that would encompass those documents. So those documents should all hopefully be being referred to, being shown to the judge by way of submissions, and shown to witnesses if there's some sort of factual disagreement about them. That, of course, might be slightly different to taking a witness through a document that simply says what it says just for the sake of reading it out in court so that everyone can hear it being read out in court. Again, that's something that judges might not like and might not have liked before this. But certainly, yes, I think there's no excuse for trying to ambush anyone with anything or not put something to a witness deliberately. Might happen potentially. Yes, I think we will probably see slightly more of a focus in terms of submissions about documents, simply because we might see less of witnesses seeking to introduce them. And then, Nick, I see there's a question in the Q&A again. As an in-house solicitor, I'm often required to give evidence on behalf of the business. Is there an issue with signing both the statement of truth and the certificate of compliance as both the witness and the solicitor? I don't know if that's anything that you've seen anything about in your consideration of the rules.
So I know I was going to respond by saying I think that's an interesting question, which means I'm probably not going to give an answer to it. So when I've just had a brief look over the rules again, there isn't anything to my mind which would say that it's not allowed. I think it's simply one of those, if you are both the witness and also the relevant legal representative as defined in the paragraph, then you are the person that will need to be signing that statement. So I think it's simply comes down to that, whether you are the legal representative or whether in that circumstance, if you're providing evidence, is there also another legal representative that needs to be signing it as well? But there's nothing to my mind anyway that immediately says that you can't do that.
And again, this might potentially be a show your working situation, mightn't it? Whereby if that's what you're doing, if you take the view that you can do that and should do that, then explaining that you've done that in both capacities because it seems to you that that's the appropriate thing to do. Again, if that then means that the judge thinks otherwise, the judge understands that you've done what you've done because you've tried your best to do what seemed to you to be right under the practice direction. So it's perhaps difficult for a judge to be too angry about that if a judge disagrees with that approach. And then maybe if we think about one last question, which I see has been asked here: what if you have an individual client who has to search for documents and provide a statement? They will already be tarnished by the searches they have undertaken. Presumably the court will understand this. I think you will certainly have situations, not only that situation, but you will have situations, of course, where you've got a client or a witness who has already been looking at stuff and digging through stuff and documents and discussing things before you've got at them and being able to deal with the process of getting their evidence in as clean and as sort of non-polluted a way as you can. In that situation, and again, yeah, particularly if that's a witness who has had to deal with that, then I think a court is likely to be understanding. Again, the idea is for you to explain the process. This is, I think, not an exercise in trying to punish people for what they've seen. This is more an exercise in trying to enable the court to know what it's looking at. And actually, as I say, I think if the court knows that this is the process that's been followed, these are the potential limitations with this witness's evidence that may therefore arise, I think the fact that the court is aware of that is unlikely to lead to the court taking a more negative view of the witness as a whole at all, because, as I say, the danger is that judges may well think the worst if there doesn't appear to be any ability to get to the bottom of to what extent evidence has been, if you like, corrupted. So with that, I think maybe if we call the questions to a close, because Ben, I know you want to close at 2 o'clock.
Thank you. I'm not sure how everyone else feels, but I think after my initial typical lawyer's sort of grumpiness of not liking change, I'm feeling a bit more encouraged now that, in fact, it might end up costing less for the clients in terms of doing things that we should never have done in the first place by providing the narrative story, which does take up a huge amount of time. I think it does, as Oliver, you mentioned, it sort of leaves a question as to who does provide the story, and I can see that ending up being potentially for opening submissions for counsel, which is fine by me if we can pass on that little task to you. But it doesn't necessarily help in terms of having clarity on the story early on, which would potentially then help lead to settlement. But I guess, how often is it that you really see a witness statement that ever says anything that's unexpected and really makes any difference anyway? It's pretty rare, I think. So yeah, thanks both for that. Really useful, interesting session, and I found it reassuring in terms of what we're going to have to do. I haven't yet had to do a trial witness statement under the new practice direction, but fingers crossed it won't be quite as awful as I thought it was going to be about 6 months ago. So thank you very much. And yeah, we'll be sending out the slides after this session. Do subscribe to the. I sound like someone who's doing a podcast, don't I? Do subscribe to the BLS YouTube channel. That would be great. Thank you for everyone for attending, and do keep your eye out for the future sessions, of which there are many. Thanks all.